Table of contents. Definition, who undergoes it, and the submission deadline. Why it matters. The three verification categories: legal, technical, financial. Passing, failing, and the award price rule. Timelines. Step-by-step procedure. Goods, infrastructure, and consulting services, compared. Applicability by mode of procurement. Virtual conduct, documents checklist, and closing. Next slide. What this reference covers. This reference is a single, comprehensive treatment of post-qualification, the fifth and final stage in this series, and the last verification step before a contract is actually awarded. It follows the same structure as the companion guides on the pre-procurement conference, the pre-bid conference, bid opening, and bid evaluation. Post-qualification is where the process shifts from evaluating what a bidder claimed in its bid to verifying whether those claims are actually true. Through three specific categories: legal, technical, and financial. Every citation has been checked directly against the full, official text of the implementing rules and regulations of Republic Act No. 12,009. Next slide. Section 1. Definition, who undergoes it, and the submission deadline. What post-qualification actually is, which single bidder undergoes it, and the tight 5-day window that starts the process. Next slide. Section 1.1. Definition. Post-qualification is the process of verifying and validating whether the bidder with the lowest calculated bid, the most economically advantageous bid, the most advantageous bid, or the highest rated bid genuinely complies with and is responsive to all the requirements and conditions in the bidding documents. It is not a re-evaluation of the bid's merits that already happened at bid evaluation. It is an independent verification exercise, checking the winning bidder's sworn representations against real, external evidence. Next slide. Section 1.2. Legal basis, who undergoes it. Legal basis, IRR of RA number 12,009, Section 63. 1. The bidder with the LCB, MAB, or the MEAB, in the case of goods and infrastructure projects, or the HRB, in the case of consulting services, shall undergo post-qualification to determine whether the bidder concerned complies with and is responsive to all the requirements and conditions as specified in the bidding documents. This is an important requirement to check during a compliance review. Next slide. Section 1.2. Only one bidder at a time undergoes this. Post-qualification is not conducted on every bidder who submitted, only on the single bidder currently ranked first, the LCB, MEAB, MAB, or HRB, depending on the award criterion and project type. Only if that bidder fails does the process move to the next rank bidder, discussed in Section 4 of this reference. Next slide. Section 1.3. Legal basis, the 5-day submission deadline. Legal basis, IRR of RA number 12,009, Section 63. 2. Within 5 calendar days from receipt by the bidder of the notice from the back that the bidder has the LCB, MEAB, MAB, or HRB, the bidder shall submit all the eligibility documents supporting its PhilGEPS certificate of registration, platinum membership, its latest income and business tax returns filed for the preceding quarter, which should not be earlier than 2 quarters from the date of submission and receipt of bid, and other appropriate licenses and permits required by law and stated in the bidding documents. Next slide. Section 1.3. This deadline has real teeth. Missing it, or being caught in a lie, both lead to disqualification for award. Section 63. 2 continues. Failure to submit any of the post-qualification requirements on time, or a finding against the veracity of what was submitted, shall disqualify the bidder for award. And if a finding against veracity is specifically made, that triggers forfeiture of the bid security under Article 21 of the Act. This is a meaningfully harsher consequence than simply losing the ranking. It is a financial penalty for submitting false information. Next slide. Section 2. Why it matters. What post-qualification protects that no earlier stage in this series is actually designed to catch. Next slide. Section 2.1. The shift from claims to verified facts. Every earlier stage in this series relies substantially on the bidder's own sworn representations. The Omnibus Sworn Statement, the SLCC Statement, the NFCC Computation. All discussed in the companion guide on bid opening. Post-qualification is where the government actually checks those representations against independent, verifiable evidence, rather than simply accepting them at face value. This is also the last point at which a defect can be caught before contract award. Once the notice of award is issued, unwinding an award because of a defect that should have been caught here is far more disruptive and legally complicated. Next slide. Section 2.2. The blacklist check is uniquely available only here. The specific check against the GPPB's consolidated blacklist portal, discussed fully in the next section, is not repeated at any earlier stage in this series. A bidder's own omnibus sworn statement already declares it is not blacklisted. Post-qualification is where that declaration is independently verified, rather than simply trusted. Next slide. Section 3. The three verification categories: legal, technical, financial. The complete, non-discretionary framework post-qualification actually runs on next slide. Section 3.1. Legal basis, the three categories, in full. Legal basis, IRR of RA number 12,009, Section 63. 3. During post-qualification, the BAC shall verify and validate the veracity, authenticity, and validity of all the eligibility documents, using non-discretionary criteria. These criteria shall consider, but shall not be limited to the following: legal requirements. To verify, validate, and ascertain licenses, certificates, permits, and agreements submitted by the bidder, and the fact that it is not included in any blacklist. B. Technical requirements. To verify and validate the bidder's stated compliance with the requirements specified in the bidding documents. C. Financial requirements. To verify and validate the bid price proposal. And, whenever applicable, the required committed line of credit, or the bidder's NFCC, to ensure that the bidder can sustain the operating cash flow of the transaction. Next slide. Section 3.1. Legal, technical, and financial verification, side by side. Category: what is verified, example checks. Legal, licenses, certificates, permits, agreements, and blacklist status, cross-check against the GPPB blacklist portal, confirm PCAB license validity. Technical, stated compliance with the bidding documents requirements, confirm equipment ownership, lease, personnel qualifications, and specification conformity are genuine, not just claimed. Financial, the bid price proposal, and the NFCC or committed line of credit, confirm the AFS figures behind the NFCC are authentic and current. Confirm the line of credit is genuinely committed. Next slide. Section 3.2. Legal basis, the blacklist portal. Legal basis, IRR of RA number 12,009, Section 63. 3. For this purpose, the GPPB shall maintain a portal which contains the consolidated file of all blacklisted suppliers, contractors, and consultants. Government personnel should follow this provision closely to avoid procedural defects. Next slide. Section 3.2. Why this one sentence matters so much. This sentence creates a single, government-maintained, centralized authority a BAC can and must actually check, rather than relying on informal knowledge or the bidder's own sworn word. A bidder's omnibus sworn statement already declares it is not blacklisted. The GPPB portal is where that specific declaration gets independently tested. A blacklisting anywhere in the country, imposed by any procuring entity, is meant to be visible through this one consolidated portal, closing the gap where a supplier blacklisted by one agency might otherwise simply bid, undetected, on a project run by a different one. Next slide. Section 3.3. Legal requirements, elaborated. This verifies the authenticity of every license, certificate, permit, and agreement the bidder submitted, not merely their presence. A PCAB license is checked against PCAB's own registry, not simply accepted as a photocopy. A MERS permit is checked for genuine issuance, current validity, and, where expired with an official receipt of renewal, that the renewal claim is real. This is also where corporate documents, SEC, DTI, or CDA registration, are checked for consistency with the bidder's declared legal personality, and where any joint venture agreement is checked for proper execution. Next slide. Section 3.4. Technical requirements, elaborated. This verifies that what the bidder claimed in its technical proposal is actually true. Personnel genuinely employed or committed to the project. Equipment genuinely owned or under a real lease agreement, specifications genuinely conforming to the terms of reference or technical specifications, not merely asserted on paper. For infrastructure projects, this frequently includes confirming the SLCC claims supporting owner's Certificate of Final Acceptance, or CPES rating, is authentic and actually issued by the party it claims to be from. Next slide. Section 3.5. Financial requirements, elaborated. This verifies the NFCC computation is traceable to a genuine, BER-filed audited financial statement, not merely a company-prepared document never actually submitted to the BER. Since the NFCC formula is specifically anchored to that filed AFS, where a committed line of credit is submitted instead, this verifies the credit is genuinely committed to this specific transaction, in the amount and for the period the bidding documents require, not a general credit facility that could just as easily be drawn down elsewhere. Next slide. Section 4. Passing, failing, and the award price rule. What happens the moment the BAC makes its determination, in either direction? Next slide. Section 4.1. Legal basis, passing, and the award price rule. Legal basis. IRR of RA number 12,009, Section 63. 4. If the BAC determines that the bidder passes all the criteria for post-qualification, it shall declare the said bid as the LCRB, MIR-B, or MARB, and recommend to the HOPE the award of contract to the said bidder at its submitted bid price or its calculated bid price, whichever is lower, or, in the case of quality-based evaluation procedure, submitted bid price or its negotiated price, whichever is lower. Next slide. Section 4.1. A detail easy to miss for consulting services. For most projects, the comparison is between the submitted bid price and the calculated bid price, whichever is lower. But for consulting services evaluated under the quality-based procedure, discussed in the companion guide on bid evaluation, there is no calculated price to compare, since price was never scored, only negotiated. The comparison there is instead between the submitted bid price and the negotiated price, whichever is lower. Next slide. Section 4.2. Legal basis, failing, and moving to the next bidder. Legal basis. IRR of RA number 12,009, Section 63. 5, 63. 6, and 63. 7. If, however, the BAC determines that the bidder fails the criteria for post-qualification, it shall immediately notify the said bidder in writing of its post-disqualification and the grounds for it. Immediately after, and notwithstanding any pending request for reconsideration thereof, the BAC shall initiate and complete the same post-qualification process on the bidder with the second LCB, MEAB, MAB, or HRB. If the second bidder, however, fails the post-qualification, the procedure shall be repeated for the bidder with the next LCB, MEAB, MAB, or HRB, and so on. Next slide. Section 4.2. A pending reconsideration request does not pause this process. The BAC moves to the next bidder immediately, notwithstanding any pending request for reconsideration. This is a specific, deliberate design choice worth remembering. Even if a disqualified bidder immediately files a request for reconsideration, the BAC does not wait for that request to be resolved before starting post-qualification on the next ranked bidder. The process keeps moving. The first bidder is only restored to the top position if its reconsideration request is later granted and the second bidder has not yet been finally post-qualified in its place. Next slide. Section 5. Timelines. The 12-day standard, the 45-30-day outer limit, and the one detail unique to consulting services. Next slide. Section 5.1. Legal basis, the complete timeline rule. Legal basis, IRR of RA number 12,009, Section 63. 8. The post-qualification process shall be completed in not more than 12 calendar days from the determination of the LCB, MEAB, or MAB. For consulting services, the 12-day period to complete the post-qualification process shall reckon from the completion of the negotiation with the bidder that submitted the HRB. In exceptional cases, the post-qualification period may be extended by the HOPE. But in no case shall the aggregate period exceed 45 calendar days for goods and infrastructure projects, or 30 calendar days for consulting services. Next slide. Section 5.1. Post-qualification timeline summary. Event, timeline. Bidder submits post-qualification documents within 5 calendar days from notice of being the LCB, MEAB, MAB, HRB. Standard post-qualification process, goods, infrastructure, not more than 12 calendar days from LCB, MEAB, MAB determination. Standard post-qualification process, consulting services, not more than 12 calendar days from completion of negotiation with the HRB. Maximum aggregate period, goods and infrastructure, with HOPE extension, 45 calendar days. Maximum aggregate period, consulting services, with HOPE extension, 30 calendar days. Next slide. Section 5.2. Why consulting services measures the 12 days from a different starting point. Goods and infrastructure count from ranking, consulting services counts from the end of negotiation. For goods and infrastructure projects, the 12-day clock starts the moment the LCB, MEAB, or MAB is determined. Since ranking and pricing are already fully settled at that point. For consulting services, price is often still being negotiated even after the highest rated bid is identified. Particularly under the quality-based procedure discussed in the companion guide on bid evaluation. It would make little sense to start the post-qualification clock before that negotiation even concludes. So the IRR deliberately anchors the consulting services timeline to the completion of negotiation instead. Next slide. Section 5.3. What happens on post-disqualification, timeline-wise? Section 63. 8 closes with an important continuation. In case of post-disqualification of the top-ranked bidder, the back gets the same fresh 12-day period. And the same 45/30th day outer limit, to conduct post-qualification of the next ranked bidder. The clock effectively restarts for each successive bidder, rather than counting down from the very first determination across the whole cascading process. This continues, bidder by bidder, until either one is successfully post-qualified, or a failure of bidding is declared under Section 64. Discussed in the companion guide on bid evaluation. Next slide. Section 5 Observation. Common Audit Observation. Issue 1. Post-qualification documents not submitted within 5 days. The bidder with the LCB, MEAB, MAB, or HRB failed to submit its post-qualification documents within the 5 calendar day window, but was not disqualified as the rule requires. Legal, regulatory basis, IRR of RA number 12,009, Section 63. 2. Next slide. Section 5 Observation. Common Audit Observation. Issue 2. Consulting services timeline measured from the wrong starting point. A consulting services post-qualifications 12-day period was measured from the determination of the highest rated bid, rather than from the completion of negotiation with that same bidder, as Section 63. 8 specifically requires. Legal, regulatory basis, IRR of RA number 12,009, Section 63. 8. Next slide. Section 5 Observation. Common Audit Observation. Issue 3. Post-qualification process exceeded the maximum aggregate period. The total post-qualification period, including any HOPE-approved extension, exceeded 45 calendar days for a goods or infrastructure procurement, or 30 calendar days for consulting services. Legal, regulatory basis, IRR of RA number 12,009, Section 63. 8. Next slide. Section 6. Step-by-step procedure. The complete sequence, from notification through a final recommendation for award. Next slide. Section 6.1. Post-qualification, step-by-step, 1 of 2. Step 1. Notify the top-ranked bidder. The LCB, MEAB, MAB, or HRB is notified it must undergo post-qualification. Step 2. Bidder submits supporting documents within 5 calendar days, including updated tax returns, licenses, and permits. Step 3. Verify legal requirements, licenses, permits, agreements, and the GPPB blacklist portal. Step 4. Verify technical requirements, independently confirm the bidder's stated compliance is genuine. Step 5. Verify financial requirements, confirm the bid price, NFCC, or committed line of credit. Step 6. Apply non-discretionary criteria throughout. Every check applies identically, per the bidding document's stated criteria. Next slide. Section 6.2. Post-qualification, step-by-step, 2 of 2. Step 7. Determine pass or fail, based on all 3 categories together. Step 8. If passed, recommend award at the lower price, submitted versus calculated or negotiated for quality-based consulting services, whichever is lower. Step 9. If failed, notify in writing, with grounds, immediate written notice of post-disqualification and the specific grounds. Step 10. Move to the next ranked bidder immediately, regardless of any pending request for reconsideration from the disqualified bidder. Step 11. Repeat until a bidder passes or bidding fails. Each successive bidder gets the same fresh 12-day, up to 45 30th day, window. Step 12. Forward to award. The BAC recommends award to the HOPE, per Section 66. Next slide. Section 7. Goods, infrastructure, and consulting services, compared. The same 3-category framework, but genuinely different verification focus and evidence for each. Next slide. Section 7.1. What gets verified most heavily, by project type. Project type, where verification effort concentrates. Goods, technical conformity of the offered product to specifications, warranty and after-sales service terms, NFCC or committed line of credit. Infrastructure projects, PCAB license category and size range. SLCC supporting documents, owner's certificate of final acceptance, CPES, equipment ownership or lease, NFCC. Consulting services, key personnel qualifications and actual availability. The negotiated price versus the submitted price. Professional licenses of named personnel. Next slide. Section 7.2. Infrastructure's distinct verification burden. Infrastructure projects carry the heaviest legal requirements check of the 3 project types, because PCAB licensing is a distinct government-regulated credential with its own registry, category system, and size range rules, discussed in the companion guide on bid opening. Verifying a PCAB license is not merely checking a document exists, it is confirming the category and size range genuinely match what the project actually requires. Next slide. Section 7.3. Consulting services distinct verification burden. People, not just paper. For consulting services, technical requirements verification is less about equipment and more about people. Are the specific named key personnel in the technical proposal actually available, genuinely qualified, and not merely listed for the purpose of winning the bid while a different, less qualified team eventually performs the work? This is also the project type where the award price itself is most often the product of direct negotiation rather than pure arithmetic correction. Making the financial requirements check partly about confirming that the negotiated outcome was properly documented and did not exceed the ABC. Next slide. Section 7.4. Goods distinct verification burden, the product itself. For goods, technical requirements verification centers on the actual item being offered. Does it genuinely conform to the technical specifications? Is it from an authorized distributor where brand specificity matters? And are the warranty and delivery terms the bidder promised actually enforceable and consistent with what it can realistically deliver? Next slide. Section 7. Observation. Common audit observation. Issue 4. Key personnel in a consulting services bid not actually available. Legal, regulatory basis, IRR of RA number 12,009, Section 63. 3b. Next slide. Section 9. Applicability by mode of procurement. Which modes generate a formal post-qualification, and which use a lighter, simplified verification instead? Next slide. Section 9.1. Formal post-qualification versus lighter verification. Post-qualification, in the full Section 63 sense, presumes a ranked LCB, MEAB, MAB, or HRB emerging from a sealed, competitive bidding process. Competitive bidding, competitive dialogue, limited source bidding, and unsolicited offer with bid matching all produce exactly that. And their winning bidder undergoes this entire framework. Small value procurement, direct contracting, and most negotiated procurement grounds instead involve a lighter verification. Often completed before a purchase order or notice to proceed is issued, without the formal 12-day Section 63 process. The GPPB blacklist portal check being the one element still worth applying regardless of mode. Next slide. Section 9.2. Applicability, mode by mode. Mode of procurement, formal post-qualification, Section 63, applies. Competitive bidding, dialogue, limited source, unsolicited offer, yes, in full, per Section 63. Small value procurement, lighter verification before purchase order, not the full 12-day Section 63 process. Direct contracting, verification of the single identified supplier's documents, not the full Section 63 process. Most negotiated procurement grounds, verification of the identified party's documents, not the full Section 63 process. Consulting services, any competitive selection mode, yes, in full, per Section 63, with the negotiation-based timeline adjustment. Next slide. Section 9.3. The one element worth applying regardless of mode. Even where the full, formal Section 63 process does not strictly apply. Checking a prospective supplier or contractor against the GPPB blacklist portal is good practice for every mode of procurement, since the underlying risk. Transacting with a blacklisted party does not disappear simply because the mode is smaller in scale. Next slide. Section 9. Observation. Common audit observation. Issue 8. Formal post-qualification framework misapplied to a non-competitive mode. A BAC either incorrectly applied the full Section 63 12-day process to a small value procurement or direct contracting transaction. Or incorrectly skipped even a basic verification, including the blacklist check, for a genuine competitive bidding winner. Legal, regulatory basis, IRR of RA number 12,009, Section 63, Section 26. 1. Next slide. Section 10. Top 20 reasons a bidder fails post-qualification. Organized by the same 3 verification categories, this entire guide is built on, spanning goods, infrastructure, and consulting services. Next slide. Section 10.1. Why this list is organized the way it is. Unlike the top 20 list in the companion guide on bid opening, which covers mechanical and documentary defects caught at the moment of opening. This list covers verification failures, cases where a document was present and appeared compliant, but did not survive independent checking under Section 63. 3. The first 7 reasons fall under legal requirements, the next 7 under technical requirements, the next 5 under financial requirements, and the final one is procedural. Tied to the 5-day submission deadline itself. Next slide. Section 10.2. Reasons 1 to 7, legal requirements failures. Reason, basis. 1. Fill gaps platinum registration expired or suspended at the time of verification, section 63. 3. 2. Bidder found on the GPPB blacklist portal, section 63. 3. Section 54. 3. PCAB license expired, or in the wrong category, size range for the project, infrastructure, section 63. 3. 4. MERS, business permit found falsified, or claimed renewal never actually filed, section 63. 3. 5. SEC, DTI, CDA registration inconsistent with the bidder's declared legal personality, section 63. 3. 6. Joint venture agreement found improperly executed or not binding all named partners, section 63. 3. Section 52. 2. 7. A license or permit stated in the bidding documents not submitted or verified within 5 days, section 63. 2. Next slide. Section 10.3. Reasons 8 to 14. Technical requirements failures. Reason, basis. 8. SLCC's supporting owner's certificate of final acceptance found falsified or unverifiable, infrastructure, section 63. 3. B. Section 52. 4. 2. 5. 9. Equipment claimed as owned or leased not actually available or verifiable, section 63. 3. B. 10. Key personnel named in a consulting services bid not actually available or committed, section 63. 3. B. 11. The product or goods offered found not to conform to the technical specifications upon inspection, section 63. 3. B. 12. Professional licenses of named technical personnel found invalid, expired, or fabricated, section 63. 3. B. 13. Ongoing contract commitments understated, misrepresenting actual current capacity, section 63. 3. B. Section 54. 2. 14. Technical specifications compliance matrix found to contain false or unverifiable claims, section 63. 3. B. Next slide. Section 10.4. Reasons 15 to 20. Financial requirements and procedural failures. Reason, basis. 15. NFCC computation traced to an audited financial statement never actually filed with the BIR, section 63. 3. C. Section 52. 4. 1. 4. 16. AFS figures inconsistent with the bidder's actual BIR filed tax return, section 63. 3. C. 17. Committed line of credit found not genuinely committed to this specific transaction, section 63. 3. C. 18. Income, business tax return submitted outside the required 2-quarter filing window, section 63. 2. 19. Bid price found unsustainable given the bidder's actually verified financial capacity, section 63. 3. C. 20. Post-qualification documents not submitted within 5 days, or a veracity finding made, without proper disqualification applied, section 63. 2. Next slide. Section 10.5. Reading the pattern across all 20. Every single one of these 20 reasons is really the same underlying event, wearing 20 different costumes, something the bidder claimed, in a document, a certification, or a stated commitment, did not survive independent verification against a real, external source. A BAC that systematically checks a winning bidder against these 20 specific failure points, rather than simply confirming the required documents are present, is doing exactly what section 63. 3's veracity, authenticity, and validity language actually demands. Next slide. Section 10, continued. Virtual conduct, documents checklist, and closing. How post-qualifications internal verification work may be conducted electronically. Everything that should exist on file, and a final synthesis. Next slide. Section 10.6. Legal basis, the general rule for electronic BAC, TWG meetings. Legal basis. IRR of RA number 12,009, Section 42. 3. In relation to Section 42. 1. L. 6. Meetings of the BAC may be conducted electronically for procuring entities with video conferencing, webcasting, or similar technology capability. Section 42. 1. L. Lists post-qualification among the functions the BAC may delegate to a technical working group. This rule is often a point of focus when verifying compliance with the law. Next slide. Section 10.6. Why post-qualification has no separate, dedicated virtual provision. Like bid evaluation, post-qualification has no standalone video conferencing clause of its own, since it is internal BAC or TWG verification work, not a public-facing event. It is governed by the same general electronic meeting rule discussed throughout this series. A BAC or TWG may conduct its legal, technical, and financial verification, including reviewing the GPPB blacklist portal and any submitted documents, through video conferencing, provided the procuring entity genuinely has that technology and a valid quorum is maintained. Next slide. Section 10.7. Documents needed for post-qualification. Updated PhilGEPS eligibility documents supporting the Platinum Membership Certificate. The bidder's latest income and business tax returns, filed within the required 2-quarter window. All appropriate licenses and permits required by law and stated in the bidding documents. Supporting documentation for the SLCC and NFCC claims made earlier in the bid for independent verification. A completed verification checklist covering legal, technical, and financial requirements, including a documented GPPB blacklist portal check. The written notice of post-qualification result, whether passing or post-disqualifying, with grounds stated if failing. Next slide. Section 10.8. The 9 numbered observations, plus the top 20, consolidated. 1 to 3. Deadline, timeline, and aggregate period failures. 4. Key personnel not actually available, consulting services. 5 to 7. By administration equipment, labor verification errors. 8. Formal framework misapplied to a non-competitive mode. Plus the top 20 specific verification failure points across legal, technical, and financial requirements, spanning goods, infrastructure, and consulting services alike. Next slide. Section 10.9. The single idea behind this entire guide. Post-qualification exists because every earlier stage in this 5-part series, the pre-procurement conference, the pre-bid conference, bid opening, and bid evaluation, necessarily relies on what a bidder claims about itself. This final stage is where those claims are finally tested against independent, external truth, before the government commits public funds to that bidder. A BAC that treats this stage with the same rigor as the rest of the series, checking all 3 categories, respecting the timelines, applying the correct rules for the correct project type and mode, and never skipping the blacklist check, closes the loop this entire guide has been building toward. Next slide. End of guide. Post-qualification is where a claim finally becomes a verified fact, or is exposed as neither. This closes the 5-part series covered across these guides. The pre-procurement conference confirmed internal readiness. The pre-bid conference engaged the market. Bid opening made sealed bids public. Bid evaluation turned bids into ranked, corrected figures, and post-qualification independently verified that the winning bidder's legal, technical, and financial representations were actually true. Every stage exists to catch a different kind of failure before public funds are ever committed.